In both of these matters, Mr. Cook failed to appear for a hearing on June 7th, 2023. Bench warrants were issued in both matters. In the 3828 matter, this is the 11th bench warrant. In the 895 matter, this is the 10th bench warrant. Current bond in the 3828 matter is $1,096. In the 895 matter, it is $1,041. In both of these matters, income withholding is currently in place and collecting. Last payments made as of today's information was July 13th, and those are coming in through Diverse Staffing, which is a temporary agency. At this time, friend of the court's requesting the next hearing be set for August 2nd at 8:45 before your honor.
Mr. Cook, you're before the court charged with civil contempt of court as a result of your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 2nd, 2023 at 8:45 a.m. Are you able to post a bond, sir?
Yes, I'm working right now. They take money every week on my check.
Okay. My question was, so are you able to post a bond?
Yes, it depends on how much is the bond.
Well, let me ask you, because you're paying through income withholding, so I'll try to be reasonable with you. What money do you have that you could post for a bond?
At this moment, I don't know what the bond are, so I can't tell you I can post it if I don't know how much it is. Because
okay, I'm trying to ask you what money you have available to post for a bond, regardless of what I set it at.
Oh, okay. So I could have to call someone to see if they come post it for me.
Okay. So far you still haven't told me anything. Do you have let's say if I set your bond in the amount of $100 each, so it'd be $200, would you be able to pay that to get bonded out?
Yes, I will.
Okay. Because obviously you're working, paying through income withholding, so I'd want that to continue. Court will set your bond in the amount of $100 in each case. So it's $200 total. If you post that, you'd be able to be released. Okay, sir?
Okay.
Okay, thank you.
Both of these matters, Mr. Noble failed to appear for show cause hearings on March 11th, 2021 before referee Delmont. In the 2019 matter, this is his first and only bench warrant. In the 2016 matter, there have been 4 prior bench warrants. Current bond in the 2019 matter is $847. In the 2016 matter, it is $2,014. In both of these matters, last payments were made involuntarily through collection in 2021, and no new report of employer. Friend of the court requests the next hearings be set for August 2nd at 8:45 before your honor.
Okay. Mr. Noble, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 2nd, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Well, that'd be fine and dandy, except for I'm not Mr. Noble.
Okay.
Oh, well, they did them in a different order then. Are you?
Okay. What's your name, sir?
My name's Timothy McGee.
Okay.
All right.
Sorry about that, you guys. I didn't want to cut you off.
No, that's okay. They normally do them right in the order they give them to us. Then we'll do case 19, Timothy McGee. In this matter, Mr. McGee failed to appear on November 9th of 2022. That was an adjourned enforcement matter before your honor. This is the 4th bench warrant with bond currently set at $3,599. No new report of employer, and last payment was a bond collection forfeiture in September of 2022. Friend of the court requests this matter go back before your honor on August 2nd at 8 a.m.
Okay. Mr. McGee, again, you're before the court as a result of your failure to appear at a prior hearing, as a result of your failure to pay child support. Are you able to post a bond in this matter, sir?
No, I'm not. My family's all gone. I got upper respiratory stage 4 cancer. I'm dying. I can't even work no more. My daughter's 30 years old. Her mom don't even want nothing to do with this case no more. She don't even come down here. Don't participate. Don't do anything. I don't even know why I'm still here for this. I'm just waiting to die, really, pretty much at this point. But
Okay,
if I die in here, at least I got a roof over my head and food in my stomach, so I ain't worried about it.
okay,
My nephew reluctantly bonded me out last time and allowed the court to keep the money. And that's probably all I can do at this point. Both my legs are burned all the way up past the
okay.
knees, 3rd-degree burns deep all the way through. I'm just in terrible shape. Ain't had a home in a couple years. I've been in a homeless camp, and
Okay,
yeah, I'm not able to do that. I got about $800 saved up that I was hoping I could use to maybe get a place to stay or something, but I ain't got no way to get to it because I'm in here. So I mean, nobody can access it but me, and I can't access it from in here. But I mean, if you want to PR bond me, I swear I'll come back to court. That's not a problem. I was in court last time for this stuff. I didn't get a notice. The only court appearance I had was on the telephone.
okay,
I didn't have a one that I had to come in and sit down and see a judge.
okay.
And being as I'm homeless and all that, my mail's been real sporadic. And having to work in telephone has also been kind of a problem for me too, but I'm trying, Judge, I'm trying.
Okay. Well, what I'm going to do is I'm going to reduce your bond in hopes that you could be released pending the August 2nd hearing. I'm going to set your bond in the amount of $400 and we'll just do it that way. Okay, sir, you're free to go.
2016 matter,
Thank you.
this is the 4th bench warrant with bond currently set at $2,014. In the 2019 matter, this is the first and only bench warrant with bond set at $847. In both of these matters, Mr. Noble failed to appear on March 11th of 2021 for a show cause before referee Delmont. There's no new report of employment, and last payment collected was through involuntary garnishment in June of 2021. Friend of the court requests the next hearings in both of these matters be set for August 2nd at 8:45.
Mr. Noble, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 2nd, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Not of that amount.
Okay. Well, I understand, guys. It's about just under $3,000. What I'm going to do is I'm going to reduce your bonds in hopes that you could be released pending that particular hearing. I'm taking into account on the 2016, you do have 4 bench warrants, and I'm also considering that you haven't paid in over 2 years. So what I'm going to do is I'm going to set the bond in both cases in the amount of $300. So if you're able to post the $300 in each case, then you'd be able to be released. Do you have any questions?
Well, I have $100 and some on my account, and I got a $60 I got $60 on my CSL. I donate plasma. I got a $60 on that card.
Okay. Well, you're going to have to come up with 600 total on both cases to be released. So
You said 600 on 3. You said 3 on both.
3 on both cases, so it's 600 total. 300 each case.
Okay.
Okay. Okay, you're free to go, sir. Thank you. Court will note the appearance of Mr. Schaefer on behalf of the plaintiff and Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion to resume court-ordered parenting time. Ms. Greenlee-Clore, go ahead.
Thank you, Your Honor. We're here again on this motion. My client has had this child, primary physical custody of this child since 2013. That was due to Miss Bailey having an insecure household, her having some mental health issues, and her threatening to abscond from the state of Michigan with a minor child. At this point, my client is just trying to get his son back. The parties agreed that while this matter was being sorted out, that Miss Bailey would have the minor child stay with her aunt for a weekend until they sorted this out. Shortly after that, the child arrived at the aunt's. Stephanie went and hired an attorney and filed this ex parte motion. This was never an agreement of the parties that this child was going to go and stay long-term with mother, or that the child was going to somehow start attending school in a different school district. Mother has withheld this child for 3.5 school weeks at the end of the school year. Didn't take this child to school at all. This child sat at home. This child has now been interviewed by CPS in her home when that's what she's saying that my client's going to do. And at this point, she's completely withholding this child. My client just wants this child back. Essentially, custody has been changed without a full hearing in this matter. Based on the response here, it looks like Stephanie has now enrolled the minor child in schools in Springfield Middle School. There's no motion pending to change schools here. This child needs to be returned, frankly, to my client immediately. This child is in danger at Stephanie's house. Stephanie has now allowed this child to be interviewed by CPS in her home. She's talked with CPS in her home, and everything that she's alleged that has kept this child with her has now happened in her home. This child is not safe in her home, obviously. She's not protecting the interests of this child in her home, obviously. She apparently plans to change the school district of this child without permission of my client or this court. She's withheld the child from school for 3.5 weeks. This child was an AB student. We don't even know what happened with his grades yet for the end of the school year in Allegan County, but he probably needs to be in summer school. Stephanie hasn't talked to my client or won't talk to my client about that. At this point, there's no reason this child should be withheld. This court last ordered that my client show proof that the CPS investigation and criminal investigation were over. However, there were no investigations. We can't show any proof that these investigations were happening or that they're over because they never happened in the first place. The police did initially do a forensic interview with the minor child, no, but that's it. Nothing was found. Nothing's going forward. We don't know what happened with Stephanie having CPS in her home, but it can only be presumed that it's due to the condition of her home and the concerns in her home that are long-term. And again, this court removed her primary custody for a reason. This child has lived with my client since 2013. There's been no motion to change custody at this point. She has had temporary care of this child pursuant to the court order. At this point, this child needs to be returned immediately to my client's household. My client hasn't had contact with this child. My client hasn't seen this child. This child needs to be returned. If this court wants to do an evidentiary hearing on this, we can certainly move forward at that point. But on a temporary basis, this child needs to be returned to his primary established custodial environment with father. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, these are the same issues that were brought up on the ex parte motion and the reconsideration of that. The circumstances were that there were allegations as set forth in the emails from the defendant's household that there was an allegation of a child in his home against this child as to improper touching. And as a result, the CPS got involved, the police got involved. And as a result of the emails whereby the defendants indicated that they were going to have the child talk to the CPS and the police was not in the best interest of this child and was not protecting this child. And that was the purpose of the ex parte motion. As a result, the child hasn't talked to the authorities in this regard. The matter is still pending. The fact that the amount of time has gone by is not demonstrative of it not going forward. And to place this child back in the same household where we have the accuser in that household is not in the best interest of this child at all. This child needs to be protected, and that was the purpose of the ex parte motion. And I think it should continue until there is absolutely no chance that this is going to go forward. And to put the child back into a household where the accuser is still in that household of children is not appropriate for this child. My client has done everything that she can do to preserve the education of this child. She's looking forward for the education in the fall. The child has gotten credit for the year. He is a good student, and to place him back in that household where you have an accuser and you have an ongoing investigation is not appropriate. So we're asking that this matter be dismissed for that reason. And also, it's the same allegations that we had before that's been denied.
Your Honor,
Hold on. Who is the accuser, and how is he related to, again, the defendant?
I believe it's one of the children in his home.
that's not true, Your Honor.
Okay.
Well, what's the accuser's name?
Your Honor, there is no accuser. The minor child at issue here is the one who indicated that he might have done something wrong. The child that he indicated he might have done something wrong to is 3. The child went through a forensic interview and nothing was found in that forensic interview. I want to bring the court's attention to paragraph 9E of mom's response here, where she indicates she talked to CPS and the minor child talked to CPS with her.
Not concerning this matter, Your Honor.
Okay.
And that just further indicates that mother has CPS involvement in her house, and which is one of the reasons why the child was removed in the first place.
Well, we don't know that. It's all just guesswork at this point. So, I mean, we can utilize hyperbole all we want. There's no allegations or anything of that particular nature. Well, the court did initially, when the court did the order, again, keeping the child in the care of the plaintiff, there were obviously some allegations at that particular time. Again, I wouldn't, this matter came back before the court on basically a ex parte motion. I don't look at those as the same as motions that are brought where the parties have opportunity to each, again, allege and to respond. So that is the reason, obviously, that the defendant's motion for ex parte relief was denied, is I wanted to have a hearing on it. I didn't want, again, additional ex parte motions just going back and forth in the case without any time to have any response. What I'm going to do in this particular matter is, obviously, the child is there's a provision under the other order for summer parenting time. The court is going to continue whatever the summer parenting time is, that would again, that would commence and continue through the summer immediately in this particular matter. I'm going to then allow the current order, the order for custody, meaning the order, not Mr. Schaefer's order, but the other order, to go back into effect. Court will reconsider that if, in fact, there is something substantial that comes out of a CPS. But if there isn't, then the court wants to put this back on the appropriate footing. And there is, as Ms. Greenlee-Clore states, there's no motion to change custody. So I'm not going to do it under the guise of a pending CPS investigation that may or may not proceed and may not be fruitful in any way. So at this point, do you understand? I guess it's kind of convoluted, but do you understand, Ms. Clore, what I'm saying?
It's my understanding that so I'm looking at the old order here from 2013. It indicates that the parties would exercise week on, week off during the summer.
Yep.
Ms. Bailey's now had the entire summer. Will my client now have his half of the summer, or will they start week on, week off immediately?
We'll do the week on, week off. I can always address any makeup at a future time. So we'll do the what day do they exchange? Is it a Friday or a Saturday?
Cody, what day do you guys exchange? Just word it.
Friday, and generally Friday to Sunday on her weekends.
Okay.
Well, no, during the summers. Have you guys been doing week on, week off during the summer?
Generally every summer we've been doing half on, half off. We never really did the whole week just because the transportation was easier, but we continued our weekends through the half of summers.
Okay. Well, do you want? I'm sorry. Go ahead.
Let's do this, because apparently we can't agree. The court will do the week, as the order said, alternating weeks, starting this Friday, where the child will go back to the defendant. And at the end of the summer, then he currently has custody, so the child would stay with him at that point, unless something else comes up with CPS. So, Ms. Clore, you can prepare that order and submit under 7-day notice of entry.
Thank you. And if I could just specify 6 p.m. on Friday?
Yeah, 6 p.m. on Friday is fine.
Okay. Thank you, Your Honor. I will.
Okay. Mr. Schaefer?
Stephanie, give me a call, please.
Okay.
Yep.
Okay, thank you. We'll conclude this matter at 9:11 a.m.
You're free to go.
On behalf of plaintiff, Ms. Huffman on behalf of defendant. This matter is before the court on the plaintiff's motion to prohibit the child from meeting the, I guess you'd say the defendant's emotional, or I guess, or I don't want to say significant other, we don't know that, but just simply the other person's partner. Ms. Podolsky, you can proceed.
Thank you, Your Honor. Complaint for divorce was filed with this motion. The parties continue to reside in the same home together with the minor child. So there is no custody or parenting time order in place. However, we do have concerns that there are significant others involved that are either romantic in nature or at least extremely emotional in nature. We do not believe it is appropriate to introduce the minor child to any such partners while the divorce is pending. So we're asking the court to put put an order in place that prohibits both parties from introducing the minor child to such a partner or prohibit further contact with such partners. We do believe this has already occurred, and so we wish that it did not occur further. We have concerns as defendant believes, because maybe something romantic hasn't occurred yet, that an emotional partner is not in fact cheating. So that's why we have included that type of language of emotional partner. Thank you.
Okay, Ms. Huffman, what's your response?
I actually filed an answer indicating that my client denies that he has any romantic partners or any type of partners. However, he would, well, and also stating that we agree with the plaintiff. We simply asked the court to grant plaintiff's motion. So,
Okay, just so I heard that correctly, Ms. Huffman, you're agreeable and you want the motion granted?
that is correct. I indicated in our answer that we were fine with the plaintiff's motion entering or us doing a consent order, that the children not be introduced to either party's significant others of any type, whether they be romantic, emotional, whatever, because my client's not doing that anyway, so he doesn't care. He's
Okay.
fine with that.
Okay. Well, Ms. Podolsky, it appears that you've got an easy motion then if we have an agreement. So if you would prepare the order and either submit it to Ms. Huffman or submit under 7-day, we can conclude the matter, and that's fine.
Sharp on behalf of plaintiff,
Ms. Podolsky
Will
on
do.
behalf
Thank
of
you, Judge.
defendant.
Thank you.
This matter is before the court on the defendant's motion to appoint a counselor. Ms. Podolsky, I note in Ms. Sharp's answer, she responds and states that the plaintiff had sent to you names of 3 counselors. Was there a reason that none of those counselors were appropriate or acceptable?
Well, actually, Your Honor, that is incorrect. We received the name of one counselor from plaintiff's former attorney. When that name was sent, my client did not agree. That's when we proposed the name of Shauna Cooper. That is an individual that this family has used in the past specifically for the minor child. That is an individual that plaintiff, in fact, chose. There were several questions that his attorney had. Those were answered. And the next thing I knew, I received a notice of substitution of attorney. So there were never 3 names sent. We do believe that Ms. Cooper would be the most appropriate individual to handle this situation. Again, this is an individual that the minor child is quite familiar with. She was originally chosen when there were concerns of self-harm. She did cease counseling with Ms. Cooper in December of 2021. That was due to some activities and extracurriculars she had going on with school, and because the issues of self-harm had also been resolved. When her extracurriculars had wrapped up, she was inquired, do you want to go back to Ms. Cooper? But she didn't feel that she needed it at that time because those issues had resolved, and she was actually in a really good place in her relationship with the plaintiff, as was testified to at the evidentiary hearing in September of 2022. At this point, as we've stated in our original motion back in May of this year, the plaintiff has not seen or spoken to the minor child since July of 2022. They, at this point, have no relationship. There's been no communication on holidays, birthdays, etc. So with this court ordering this counseling to begin, it's important that the minor child feel comfortable. That's half the battle when you're in counseling, is making sure that you have a rapport and are comfortable with the counselor. So it's important here that this minor child feels safe and comfortable in the counseling. The court ordered that the counseling is to occur here in Calhoun County. Ms. Cooper is here in Calhoun County. This is somebody the family knows, the family is familiar with, and more importantly, that the minor child is familiar with. The plaintiff has accused my client of delaying this process, which is incorrect. My client's the one to file this motion to ask for a specific counselor. When the plaintiff is seeking additional time for the parties to come up with more names and have the court appoint a counselor 30 plus days down the road, when we could get this started today with somebody the minor child knows. So we're asking this court to appoint Ms. Cooper as the counselor. We're asking that the counseling begin and to be in person, so the minor child can be assured that it is just her, the counselor, and her father in the room, that there aren't any third parties present who are potentially putting their own ideas into the counseling or influencing the counseling. So we're asking the court to make that order today. Thank you.
Okay, thank you. Ms. Sharp?
Thank you, Your Honor. My client actually was filing dual motions at the same time. He's withdrawn his motion, but the reason he got a new attorney was because he did provide 3 different places to be able to do that were located in Calhoun County to be able to do their reunification counseling. And all 3 were turned down by at least what he's been informed due to his, previous attorney. He wanted to make sure that this was done, and that is why he sought different counseling or different counsel. The reasoning, there's numerous reasons why he does not feel comfortable with Ms. Cooper. First off, this was a child's individual counselor. This is not a reunification counselor. This counselor was specialized in self-harm. Both parties agreed in December of 2021 that this counseling wasn't helping, so there was really no reason why to continue it. And so in the end, my client does not feel comfortable with this counselor, but also she would not provide my client full information. She didn't treat my client the same as she treated the defendant. So my client doesn't feel comfortable with her. And does not want to proceed. This is purely just to focus on the child and the defendant, or in my client, the plaintiff. And so it comes down to my client doesn't want to delay this. We were trying to make it fair by making it that each party provide 3 names. But my client would actually just like to be able to pick the counselor and be done, because this counseling specifically is regarding him and his daughter. And this counselor should not be biased. I do believe that the parties should meet with the counselor initially together, not just my client, and that would make it extremely fair. But to use a child's individual counselor defeats the purpose to begin with, because if she needs to start seeing an individual counselor in the future, we want to have this option open. But my client does not feel comfortable with this counselor to begin with, and would like to have somebody that actually specializes in reunification counseling, not self-harm.
Okay.
And the 3 places, I can provide the 3 places that he had given, and it was Comforts of Home Counseling and Care Management, Avalon Behavioral Health, and Primary Care Psychology, and wanted to work with her on a counselor specifically from those 3 places, simply just, to also see if she'd be open to, if she had a different say and a different counselor there. But also is because there's supposed to be an intake process. An intake process then would name which counselor would probably be best for the situation. Thank you.
Okay, thank you. Ms. Podolsky, any response?
Thank you, Your Honor. These parties did not have a discussion about terminating the counseling with the minor child. The discussion was, is the particular counselor, Ms. Cooper, was she the best fit at that time? And it was the minor child who said, yes, this is the person that I'm comfortable with and I have a rapport with. Again, this is a parent who has not seen or spoken to his own child by his own decision since July of 2022. We have an almost 16-year-old who has a treatment provider that she has seen in the past, chosen by plaintiff, that she is comfortable with. And I think considering this entire situation and the testimony that this court heard back in September of 2022, that it is important to make this minor child comfortable after what she has gone through in this relationship. So to have somebody who is familiar with the minor child, familiar with the family, who could essentially hit the ground running here would be in the best interests of this family. And again, I can certainly say those names were not provided. Comforts of Home was the only one that was provided to us. And that's when Ms. Cooper was suggested, because we do believe that that's what's in the best interest of the minor child.
Okay. Well, in this particular matter, the court does note that Ms. Cooper was providing individual counseling, and apparently that worked well. But we're talking about reunification counseling, which does require different skills, et cetera, for the most part. What the court's going to do is order that each of the parties would provide the court with 3 counselors, and that would be provided within 7 days of today's date. The court will then choose the person that will provide the counselor, and we'll give that as soon as we get all the names. If we got them before 7 days, the court could again choose the name and send out an order ordering that person to conduct the counseling. So please get that to me as quick as you can so we can get that started, and that will be, I'll ask Ms. Sharp. No, it's Ms. Podolsky. I'd order, Ms. Podolsky, it's your motion, so I'd order that you would prepare the order directing the the disclosure of those names.
Your Honor, how would you like us to get the names to you? Do you want those just to go through court officer, or do you want
Yes,
those in order?
yes, just send those, just send them to my assistant, and she'll forward them on to me. I'll look at that. I want the names and the qualifications included in that, so I can see that the person would be qualified to do the reunification counseling.
Okay. Thank
Your
you.
Honor, I have one additional question. When it comes to the intake process, do you feel that would the court rule on the parties actually doing it together so that there is no question that there's any kind of
I have no idea what the counselor is going to want. Maybe the
Okay.
counselor would want to meet individually with everybody. I don't know. And
Okay.
I'm not going to dictate the parameters of the, note the appearance of Mr.
Okay, thank
Magnuson
you.
on behalf of the front of the court's office in this matter. The matter is before the court on the defendant's motion to set aside referee recommendation. Mr. Roush, you can proceed.
Yeah, I just wanted to object to the recommendation of sole custody and the court order with the mother. And I just believe that the numbers in the case are off, and as well that the mother should not have sole custody.
Okay. Well, sir, if you look at the order of affiliation, which the court signed back on July 14th, it provides that she would only have temporary custody at this point, the rest subject to further evidentiary hearing. You're aware of that, aren't you?
Yeah, I'm reading that now. So
okay. Okay. Mr. Magnuson, do you have any input as it relates to the front of the court?
That was the point I was going to make, Your Honor. The referee specifically did, because there was a dispute, set the matter for a further evidentiary hearing on those matters. Also, the other concern raised in the objection, I believe, is addressed through the change of domicile provision. So I would ask the court to leave the order in place and allow the process to continue, and the referee will, if it's not been scheduled yet, I'm assuming they're going to schedule it for hearing on custody and parenting time.
Okay, thank you. Well, Mr. Roush, court did review that because I saw your objection. You claimed that you believe that the plaintiff was going to flee the state, but if you look at that order, it states that the child cannot be moved from the state of Michigan without the approval of the court. So if she does it at the risk of parental kidnapping in this particular matter. So that should waylay, not to say that it will, but I'm just saying that should waylay your concerns. I did have issues as I read the order that the referee didn't consider any imputation of income to the plaintiff, simply set her income at zero. I don't know. Obviously, that's subject to, again, the further evidentiary hearing, or in your case, sir, they have that you have 0 overnights of parenting time, and I assume that would be left to the referee to address at the evidentiary hearing as well. So anything else you have to say, Mr. Roush?
okay, no, I know that we do have another date set for August 1st. When I got the paper showing the order, I just kind of panicked, like thinking that was going to be set. So it's kind of where I was at.
Well, it looks like, Mr. Rush, that everything's going to be, you say on August 1st or August 2nd, whichever the date was, that the matter will be taken up as, again, so a final order. You have a right to address all your concerns at that particular point, and the temporary order does keep her by order of the court, which is all the court can do, is order that she can't move the child out of the state of Michigan. So I think it addresses all your concerns, and I understand, again, once you receive that you had those concerns, but you'll be able to address those at the August hearing.
Okay.
Okay. So the court's going to deny the motion at this point because it looks like the referee had anticipated that and again provided for those particular contingencies, and you can address it at that time. Okay.
Okay.
Thank you. The court will end this matter at 10:38 a.m.
Morris versus Cody Morris. Attorney Jennifer Reed for plaintiff.
Okay. Good afternoon to all of you.
Good afternoon.
I'll start because Mr. Morris, you're not represented, so I'll let you know that a scheduling conference is where we attempt to put in place various dates and procedures that would cause for the orderly handling of the case as we go forward. So I will go to the plaintiff first, and then I'll give you an opportunity as we go through each one of those particular areas. Ms. Reed, what do you believe to be the issues in dispute?
Custody, parenting time, child support, property and debt division.
Okay. Anything else, Mr. Morris, that you believe we need to address?
No, sir.
Okay. And have you engaged in discovery at this point, Ms. Reed?
We have a subpoena out for Mr. Morris's income. I have not received his financial information form yet, so we need at least 30 days.
Okay. Mr. Morris, there is a form, and you probably saw in the paperwork that that within so many days after filing your answer, you have to file a financial statement. So I'll just mention that to you. If there's any information that you need or want from the plaintiff, you have a right to do that. The court's going to set a deadline of September 1st. So you'll have to have that done by that date, okay?
Okay, Your Honor.
Which means we'll send the matter to mediation. That's an attorney mediator that'll be handling it. We'll put that in September. And I'll ask Ms. Reed, who would you like as a mediator in the case?
Mr. Brundage?
Mr. Morris, do you have any problem with Mr. Brundage serving as the mediator?
No, sir.
Okay. Or we'll set October 9, 2023 at 1:30 p.m. as the settlement conference date. Parties are required to be present unless we've come to a full agreement prior to that time.